what is really a fantastic program that has been adopted here in the state of Maryland. A person is eligible for assisted outpatient treatment if they have a serious and persistent mental illness. If they have a serious and persistent mental illness that also is not being treated, then they have the opportunity to be a part of a court-ordered outpatient treatment program where they get the benefit of a care coordination team and they get the benefit of a treatment plan. That treatment plan is then monitored by the court. A person who is a good candidate for that is someone who otherwise would not avail themselves of treatment, but it is someone who does have a diagnosis of a mental health condition. A part of the assisted outpatient treatment program, as it was designed and adopted, had a provision in it that left out a key and critical feature. And it requires legislation to correct that key and critical feature that was left out. A part of the existing code states, and what was the original language of what's been adopted into law, is that this subtitle may not be construed to abridge or modify any civil right of the respondent, including any right relating to a license, permit, certification, privilege, or benefit under any law. Now, on its face, that sounds like a really good intention, and it was a good intention at the time, but what we overlooked in that is firearms. If a person has a firearm, wants to purchase a firearm, but they have a severe and persistent mental illness that is not being treated, we overlooked in adopting that provision in the original code that would not be an ideal candidate to have a firearm. So that's what this bill does, is it corrects that small loophole that was left there so that we can intervene and save lives of the people who are the subjects of these orders and those who may encounter them as well. The mechanics of the bill and the way that Senate Bill 942 works is that when a person fills out a petition for assisted outpatient treatment, they would be asked on that petition, does the person own a firearm? And then they would be asked as well, is the person likely to cause a injury to themselves or to others with a firearm? If those two things are responded to in the affirmative, then the court would be required to make a determination, and if the court finds in the evidentiary hearing that the person would be likely to harm someone, then the court shall order the surrender of firearms. And that language there, if it feels familiar because it's similar to what's in our protective order statute, similar to what's in our ERPO statute as well, and the way that the firearm would be surrendered mirrors those statutes as well. It would have the person voluntarily surrender that firearm, and if they don't voluntarily surrender, it does have some enforcement mechanisms in there where the state's attorney or law enforcement office could file for a search warrant or could use the contempt powers of the court to compel the person in to produce the firearms and could do that. I will let you know, in going through your bill folder and the testimony provided by the Department of Health, the Department of Health is not in favor of the option to use the court's contempt powers because the court's contempt powers are intentionally left out of the rest of the statute for assisted outpatient treatment by design. They wanted it to be more collaborative and less compulsory. So it's in the committee's wisdom to decide what to do there. I'll only state that when we're dealing with firearms and we're dealing with a threat to public safety and a person's own safety, that we're in a different area as it relates to someone's harm or potential harm of another. And so perhaps the contempt power of the court is an appropriate tool there. I'll also note that sometimes folks will say, well, we already have ERPO laws. Why do we need this? And several things are true in why we need this. One, for the ERPO laws, there has to be an immediate danger that's happening. The immediacy that's required in ERPO is not the same standard that's here for assisted outpatient treatment. This standard is more prospective in terms of the condition that the person has and the treatment that they're not receiving and what their behavior might be inclined to do since they're not in a state of receiving the care and the treatment that their diagnosis says that they need in order to live well to their fullest potential. Also, we don't want redundancy in the court. If we can avoid the same family, the same petitioner going in to file a AOT petition and an ERPO petition, then we'd rather simply have all of that handled in one petition so that it's streamlined and the person that's the respondent that has their due process to come in isn't the subject of multiple petitions but can have that done all at once. So for that reason, judicial economy and then just the different standards of immediacy, we believe that this is the best vehicle for doing that. You will hear from the testimony that's here for you today. There are mental health professionals who work with folks who are the beneficiaries of the AOT program that you designed. And what they will share with you is that the #1 beneficiary of passing this bill will be the respondents who are the subjects of these petitions, particularly folks who are in a position where they have suicidal ideations. What the practitioners will tell you is that in instances of attempts for suicide, the #1 most successful method for completing a suicide is when the method is by firearm. So if we are able to separate folks from firearms while they are receiving treatment for a diagnosed mental health condition, then we know that we'll be able to save lives as well. I am of the perspective as a legislator that there are some bills that we file that have a certain degree of inevitability, where you file a piece of legislation and you know that at some point something is going to happen where people will understand the usefulness for the legislation, whether it's when you file it and you can prevent something from happening, or whether it's in a future year if a bill is unsuccessful. And I believe, colleagues, that this is one of those bills that we will either revisit out of necessity, or we will take on and we will use it as a preventative measure. So with that, Madam Chair, I will turn it over to my panel and I will ask for a favorable report on Senate Bill 942.
Thank you, Senator. Cynthia Lewis.
Good afternoon, Chair and members of the committee. Thank you for the opportunity to testify in support of Senate Bill 942, adding a firearm restriction to Maryland's Assisted Outpatient Treatment Program, which becomes active in July 2026. My name is Dr. Cynthia Lewis. I am Director of Adult Psychiatric Emergency Services at the Johns Hopkins Hospital. I am co-chair of the Legislative Committee for the Maryland Psychiatric Society. I testified providing oral and written testimony for the AOT bill that got passed in 2024. The views today are my own and those of the Maryland Psychiatric Society. They are not representative of my employer. This legislation is a focused, safety-driven measure designed to reduce preventable deaths, particularly suicide, among individuals with severe mental illness who are under court-ordered assisted outpatient treatment. Suicide remains one of the leading causes of death in this population, and firearms are by far the most lethal means. When a firearm is used in a suicide attempt, death occurs in the vast majority of cases. Reducing access during periods of heightened clinical risk is one of the most effective, evidence-based strategies that we have to save lives. The purpose of this bill is not to criminalize mental illness. It is to improve safety during a period when a court has already determined that structured treatment is necessary due to significant risk and instability. Assisted outpatient treatment is a civil treatment-focused intervention. Aligning it with a temporary firearm restriction is consistent with its protective intent. Importantly, this legislation includes due process protections. Any restriction occurs within a judicial framework with clear standards and oversight. There is no criminal pathway attached to the surrender of firearms under this bill. The goal is compliance and safety, not punishment. The surrender process is civil and preventative, not prosecutorial. Most states with AOT statutes already include some form of firearm restriction. Maryland's program should reflect the same commitment to public safety and suicide prevention as we prepare for full implementation in 2026. This bill is about protecting vulnerable individuals during periods of acute risk while respecting constitutional rights and due process. It is a measured, responsible step that prioritizes life and safety. For this reason, I respectfully ask for a favorable report.